The Constitution of India is the longest written constitution of any sovereign country in the world. Additionally, it emphasizes the importance of constitutional fundamental duties, assuring its citizens justice, equality and liberty, and promoting fraternity. The Constitution of India declares India a socialist, secular and democratic republic. In contrast to many others who had become independent at the same time, the Indian Constitution has stood the test of time. Of the people, for the people, and by the people. The Indian Constitution, the longest of any sovereign nation in the world, provides a comprehensive framework to guide and govern the country. At independence, India was not merely large and diverse, but also deeply divided. For one thing, it sought to heal wounds of the past and the present, to make Indians of different classes, castes, and communities come together in a shared political experiment. Hello and a very warm welcome, viewers. You're watching this special presentation of Sansad TV on the separation of powers between different pillars of democracy in Indian Constitution. Come along. At independence, India was not merely large and diverse, but also deeply divided. A constitution designed to keep the country together and to take it forward had necessarily to be an elaborate, carefully worked out and painstakingly drafted document. For one thing, it sought to heal wounds of the past and the present, to make Indians of different classes, castes and communities come together in a shared political experiment. For another, it sought to nurture democratic institutions in what had long been a culture of hierarchy and deference. The Constitution of India was framed between December 1946 and November 1949. During this time, its drafts were discussed clause by clause in the Constituent Assembly of India. In all, the Assembly held 11 sessions, with sittings spread over 165 days. The Constitution of India was adopted by the Constituent Assembly on 26th of November 1949. The Constitution declares India to be a sovereign, socialist, secular and democratic republic.
India, that is Bharat, shall be a sovereign, democratic republic.
The importance of the Constitution of India is that it is the basic document that governs the country. The Constitution of India is important because it ensures that decision makers on behalf of the people are a fair representation of public opinion. It laid down the ways in which officials exercising power could be held accountable to the people they served. A set of rules and principles on which all the people of a country can agree are set forth by the Constitution. It provides the ways in which they want the country to be governed. It also includes an agreement on the type of government and certain ideals which they believe should be upheld in the country. The judiciary, legislature and executive are the three pillars on which the effective functioning of the government rests. These organs do not work in isolation to each other, but are interdependent to ensure proper and systematic functioning of the government. The Union Executive consists of the President, the Vice President and the Council of Ministers, with the Prime Minister as the head to aid and advise the President. Executive power of the Union is vested in the President and is exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Supreme Command of Defence Forces of the Union also vests with him. The President is elected by members of an electoral college consisting of elected members of both houses of Parliament and legislative assemblies of the states in accordance with the system of proportional representation by means of a single transferable vote. To secure uniformity among state, interstate as well as parity between the states as a whole and the Union, suitable weightage is given to each vote. The Vice President is elected by members of an electoral college consisting of members of both houses of Parliament in accordance with the system of proportional representation by means of single transferable vote. He must be a citizen of India, not less than 35 years of age and eligible for election as member of the Rajya Sabha. His term of office is 5 years and he is eligible for re-election. The Vice President is also ex officio chairman of the Rajya Sabha and acts as a president when the latter is unable to discharge his or her functions due to absence, illness or any other cause, or till the election of a new president. There is a Council of Ministers headed by the Prime Minister to aid and advise President in exercise of his functions. The Prime Minister is appointed by the President, who also appoints other ministers on the advice of Prime Minister. The Council is collectively responsible to the Lok Sabha. It is the duty of the Prime Minister to communicate to the President all decisions of Council of Ministers relating to administration of affairs of the Union and proposals for legislation and information relating to them. The Council of Ministers comprises ministers who are members of Cabinet, ministers of state or independent charge, ministers of state and deputy ministers. Parliament is the supreme legislative body of India. As in other parliamentary democracies, the Parliament in India has a cardinal function of legislation, overseeing of administration, passing of the budget, ventilation of public grievances, and discussing various subjects like development plans, national policies, and international relations. It's where our laws are framed, the country's future is debated, and the people's representatives are held accountable. It is India's seat of government, and all the important laws are passed right here in this iconic circular edifice, Parliament of India. It is the supreme legislative body and a living epitome of freedom and sovereignty of the people of India. It occupies a preeminent and pivotal position in India's democratic polity. The distribution of powers between the Union and the states, followed in the Constitution, emphasizes in many ways the general predominance of Parliament in the legislative field. Apart from a wide range of subjects, even in normal times, the Parliament can, under certain circumstances, assume legislative power with respect to a subject falling within the sphere exclusively reserved for the states. The Parliament is also vested with powers to impeach the President and to remove the judges of Supreme Court and the High Courts, the Chief Election Commissioner and the Comptroller and Auditor General in accordance with the procedure laid down in the Constitution. Legislature of the Union, which is called Parliament, consists of the President and two houses, the Rajya Sabha, also known as the Council of States, and the House of the People, also known as Lok Sabha. Each house has to meet within 6 months of its previous sitting. A joint sitting of two houses can be held in certain cases. The Constitution provides that the Rajya Sabha shall consist of 250 members, of which 12 members shall be nominated by President from amongst persons having special knowledge or practical experience in respect of such matters as literature, science, art and social service, and not more than 238 representatives of states and UTs. The maximum membership of the Lok Sabha allotted by the Constitution of India is 552. The term of the Lok Sabha, unless dissolved earlier, is 5 years from the date appointed for its first meeting.
Item number 13, Sri B.L. Verma ji.
माननीय अध्यक्ष महोदय,
Yes, allow you. No.
6 जुलाई 2021 को नए सहकारिता मंत्रालय के गठन के बाद माननीय प्रधानमंत्री के सहकारिता समृद्धि के विजन को अकल्पनीय तरह से पूरा करते हुए हमारे माननीय केंद्रीय मंत्री जी ने की ओर से जो प्रस्ताव किया है कि मैं प्रस्ताव करता हूं कि बहुराज्य सहकारी सोसाइटी अधिनियम 2002 का और संशोधन करने के लिए विधेयक को पुनर्स्थापित करने की अनुमति दी है।
अपनी बात को अंतिम रूप देते समय कहना चाहूँगा कि बहुत सारे लोगों ने बर्ड्स की बात करी और उसके लिए हमारे देश के वेटलैंड बहुत महत्वपूर्ण हैं। एक रामासर ट्रीटी है जिसके अंतर्गत अपने ऐसे वेटलैंड जिनको आप अंतर्राष्ट्रीय दर्जा दिला के संरक्षित करना चाहते हैं। भारत ने आज़ादी के 75वें वर्ष में देश की 75 वेटलैंड अब हमारी रामासर साइट्स में, जो हम सब लोगों के लिए गौरव का विषय है। बहुत बहुत धन्यवाद।
The question is that the Wildlife Protection Amendment Bill 2022 as passed by Lok Sabha be taken into consideration. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted.
India has a single integrated judicial system. The judiciary in India has a pyramidal structure with the Supreme Court at the top. High courts are below the Supreme Court and below them are the district and subordinate courts. The lower courts function under the direct superintendence of high courts. Articles 124(2) and 217 of Constitution deal with the appointment of judges to the Supreme Court and the High Courts. The chief function of the judiciary is to apply the law to specific cases or in settling disputes. When a dispute is brought before the courts, it determines the facts involved through evidence presented by the contestants. The law then proceeds to decide what law is applicable to the case and applies it. The Constitution lays down the structure and defines, delimits and demarcates the role and functions of every organ of the state, including the judiciary, and establishes norms for their interrelationships, checks and balances. The doctrine of separation of powers implies that each pillar of democracy, the executive, legislature and the judiciary, perform separate functions and act as separate entities. The doctrine is a part of the basic structure of the Indian Constitution. Concept of separation of powers was first seen in the works of Aristotle in the 4th century BC, wherein he described the three agencies of the government as General Assembly, public officials and judiciary. In the ancient Roman Republic too, a similar concept was followed. The term Res Politica or separation of powers was coined by Charles Louis de Secondant, an 18th century French social and political philosopher. His publication, Spirit of the Laws, is considered one of the great works in the history of political theory and jurisprudence, and it inspired the Declaration of the Rights of Man and Constitution of the United States. Under his model, the political authority of the state is divided into legislative, executive and judicial powers. He asserted that to most effectively promote liberty, these three powers must be separate and acting independently. Constitutional provisions ensuring separation of powers are Article 50, that says that states shall take steps to separate the judiciary from the executive. Articles 121 and 211, which says that judicial conduct of a judge of the Supreme Court and the High Courts cannot be discussed in Parliament and the state legislature. Articles 122 and 212 says that validity of proceedings in Parliament and the legislatures cannot be called into question in any court. Article 361 says the President of the Governor shall not be answerable to any court for the exercise and performance of the powers and duties of his or her office. Separation of power has been accepted and adopted across the globe. The United States has one of the most initially established versions of this doctrine, which finds its origin in its constitution. The theory of separation of powers in various aspects has been included in certain other constitutions around the world. The Australian Constitution favours the devolution of legislative functions to the executive rather than judicial institutions. This idea is also believed to be the foundation of the Sri Lankan Constitution. France is another country where this doctrine has effect, and this doctrine flows out of the French Constitution. The United Kingdom too has a separation of powers concept on an informal note. The doctrine of separation of powers seeks to protect the centralization of power in one hand. As history has repeatedly demonstrated, centralization of power in one or few hands can lead to disastrous outcomes. The application of this principle makes the government liable, accountable and answerable to its citizens for its actions, thereby aiding in the promotion and protection of human rights. This eliminates one of the most serious weaknesses of other forms of administration, such as monarchy or dictatorship, in which the king is not accountable to his people. When applied, the principle creates a balance of powers inside the government in which each of the government's bodies, functions, are kept in check by the others while remaining independent of one another. This assures that the laws are just, fair and adhere to the natural justice ideal. Furthermore, because it is independent of the other departments, the court can administer equitable justice. Democracy is flawed without separation of powers. Well, viewers, that's all we had for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side for now.